This video is for educational and informational purposes only and does not constitute legal advice. When an OSHA inspector leaves a facility and a citation arrives in the mail, many corporate executives treat it like a traffic ticket. They assume paying it quickly is the most efficient way to close the case and avoid legal fees. A standard serious violation carries a maximum penalty of $16,550. For a mid-sized enterprise, that number sits neatly below the threshold of litigation. It looks cheaper to write the check than to hire an attorney. Under Title 29 of the United States Code, Section 659, receiving this document triggers a strict 15-working-day statutory deadline to file a notice of contest. This is not a courtesy window that can be extended by agreement. If that 15-day clock expires, the citation automatically becomes a final order of the Occupational Safety and Health Review Commission. By writing the check, the employer bypasses their only opportunity for due process. They are making a formal, legally binding admission of guilt that establishes an unalterable permanent record. That permanent record provides immediate leverage for the plaintiff's bar. An OSHA investigation frequently runs parallel to civil lawsuits for personal injury or wrongful death arising from the exact same workplace incident. In many jurisdictions, violating a statutory safety standard establishes negligence per se. This means a judge instructs the jury that the company was negligent as a matter of law simply because they broke a regulatory safety rule. An uncontested OSHA citation strips a company of its civil defenses. It provides the plaintiff with a binding factual record proving the violation occurred, which can be introduced directly into civil litigation. Furthermore, this admission is uploaded to OSHA's Integrated Management Information System. It becomes a permanent public record, accessible to anyone running a background search. Paying a $16,000 fine to save a few $1,000s in legal fees multiplies the company's civil exposure, ensuring that downstream settlements will cost magnitudes more than the initial penalty. The direct penalty is only the visible surface. The true financial impact occurs beneath the surface, embedded within the workers' compensation insurance system. Most OSHA inspections are triggered by a recordable injury. Consequently, the citation is directly tied to a corresponding workers' compensation claim. Underwriters measure an employer's historical loss experience using the Experience Modification Rate, or EMR. This is a risk-weighting factor that compares a company's safety record to industry averages. This formula dictates your insurance costs. Your workers' comp annual premium equals your payroll divided by 100, multiplied by your industry classification rate and your EMR. If a fracture-level injury results in a $65,000 claim, that single claim drives a baseline EMR from 1.0 up to 1.15. For a company with an $8 million payroll, that 15-point EMR increase generates an immediate premium spike of nearly $42,000 in a single year. Because the EMR adjustment persists across a standard 3-year experience period, that annual spike compounding over time. Accepting a $16,000 citation directly correlates to an insurance tax that drains well over $120,000 from the enterprise over the next 3 years. Insurance premiums are only the first downstream consequence. The next threat comes directly from future OSHA enforcement. Once a citation becomes a final order, OSHA initiates a 5-year look-back period. This applies to any facility across the employer's entire national footprint. If an inspector finds a substantially similar hazard during that window, the violation is classified as repeat. This classification carries a 10 times multiplier, escalating a maximum $16,550 fine to $165,514. OSHA uses the uncontested Year 1 fine as the evidentiary foundation to justify the multiplier, escalating the company into the Severe Violator Enforcement Program. Beyond regulatory enforcement, this permanent public record dictates a company's ability to compete in the marketplace. Under the Federal Acquisition Regulation, specifically Section 9.104-1, contracting officers are required to conduct responsibility determinations. This explicitly evaluates a prospective contractor's compliance with safety regulations. A recent serious citation triggers an adverse responsibility finding. This disqualifies contractors from bidding on Department of Defense projects and General Services Administration schedules. An uncontested serious citation is an enterprise risk that freezes out the most lucrative revenue streams. to dismantle these risks, an employer must exercise their right to an informal conference within 15 days. This is where defense counsel scrutinizes the logic of OSHA's gravity-based penalty system. The base penalty is the product of severity and probability. By presenting evidence that a hazard had low employee exposure frequency or was isolated from standard operations, an attorney can mathematically dial down the probability rating, forcing an immediate reduction of the base fine. A reduction in the dollar amount is secondary. Defense counsel targets reclassification, negotiating to downgrade a citation from serious to other than serious. This specific reclassification protects procurement standing and removes the foundation for a 10 times repeat multiplier. Counsel also leverages the multi-employer worksite doctrine, detailed in Chapter 6 of the Field Operations Manual. On a shared worksite, liability can be shifted. An attorney will argue that while their client may have been the exposing employer, the responsibility properly belongs to the creating or controlling employer, who had the actual authority to correct the hazard. Finally, they apply the good faith reduction metric. Documented safety systems, hazard assessments, and comprehensive training programs can secure up to a 25% reduction in the penalty. By utilizing these rigid mathematical and procedural rules, defense counsel systematically dismantles the citation severity, resolving the case favorably before formal litigation ever begins. Surviving an OSHA inspection requires long-term, systematized compliance, and when an informal settlement is reached, the agreement must include a non-admission clause. This specific language explicitly states that the employer's agreement to correct a hazard and pay a reduced fine is not an admission of guilt. This shields the company against collateral estoppel and preempts civil negligence lawsuits. To earn those settlements, companies must build proactive safety and health management systems, maintaining flawless training logs and thorough job hazard analyses. This photograph shows a large-scale manufacturing operation. Securing maximum penalty reductions during an informal conference requires producing the high volume of documentation necessary to prove full facility compliance across an operation of this size. Engaging experienced counsel mitigates the immediate fine and restructures the enterprise's entire liability architecture. When a citation arrives, the response must be immediate and exact. First, explicitly log the date of receipt. Second, engage counsel immediately. Third, audit the facility for hazard abatement. And fourth, prepare for the informal conference. Internal delays are the greatest threat. You must assume the 15-day clock started the exact moment the physical letter was handed to any employee at the facility, not the day it finally reached the legal department. An OSHA citation doesn't have to become a multi-year financial burden. With the right strategy and guidance, you can negotiate and protect your company's future. If you want to learn more about OSHA compliance, citation defense, and building stronger safety programs, subscribe to the HSEstudy YouTube channel. Click here to watch our other deep dives into OSHA compliance and corporate liability defense.